Good day, everybody. Hope everybody's doing well. Attorney Greg Lake here at the Entheogenic Esquire YouTube channel and podcast. I set this live today. Well, I'll tell you what happened real quick. I actually sat down to do this video and recorded it. It was probably 20 minutes long. And then when I went to review it, there was no volume on it. So I was like, okay, well, I'll just, re-record it later. But in the mix, I realized I really prefer to do lives. And this is one of those where I might have some digressions here and there, and not long ones, but ultimately I think it's better just to do this live instead of record it. Hello, Elena. How y'all doing? Again, I realize that Candace has a show right now. So look, if y'all go watch Candace, I'm not going to be upset. This will obviously be recorded onto my channel. And really, that was ultimately what I wanted anyways. Okay. Oh, okay. She just uploaded a short preview. Oh, okay. Awesome. Well, maybe we will have a few people here. So yeah, very thankful, grateful. Rick, Elena, thank y'all for showing up. And I can't forget Miss Allie Top Files is here too. Thank you. And very much enjoyed doing the live yesterday with Allie Top Files and crew. So thank y'all very much. I think my crew enjoyed it. I think everybody enjoyed the live with Adam the other night. So we're going to do that again. Adam and I have talked, and obviously Allie and I need to get a hold of her after this. We might be doing a bit tomorrow during the court proceeding, which will be online. I guess before we start, this is relevant. I couldn't find, so watching the previous hearing for Tyler Robinson, which was basically the evidentiary hearing, and then it ended with their oral arguments to the court on this motion to disqualify the prosecutor's office. And at the end, judge signified that this hearing tomorrow, which will really just, as far as I'm aware, him rendering an order on the disqualification motion, and then I think also setting the agenda moving forward on the privacy motions, both with in regards to the press, and I think the defense's currently pending motion that's trying to keep a lot of these evidentiary motions private. So anyways, with that being said, I sent an email to the court coordinator asking for a link for tomorrow's hearing. It's going to be audio only, by the way. And just so we're aware, I went back and checked the record. It was actually Tyler Robinson's counsel that requested that it be audio only. It will be online. That was already a given, but they asked that it be audio only. So, it is what it is. Hopefully we can get through this whole mess of trying to keep everything private, and hopefully us in the media. I mean, it's the first time I'm going to say, hopefully us in the media, we win. So we'll see about that. I do know the media has some pretty good attorneys that are working on their behalf. I've read their briefs. I've spoke about them on here. So I have faith that if it's going to happen and they're going to keep these proceedings open, they're going to be able to pull it off with their current legal team. So let's just stay prayed up and hope that we can see all this go down, and hopefully if we do, it goes down in a good way, and we can feel good that justice is still alive in this country. I know that a lot of what we've been experiencing over the last 6 months or a year, even me as a lawyer have felt a breakdown in law and order, and obviously also see this multi-tier justice system that keeps popping its ugly head up here in the news media and here on YouTube too, us talking about particularly with the files release, things of that nature. So we'll dig further into that. So tonight, hey, how you doing, Moonchild? Bonnie, how you doing? Good to see all y'all. Thank y'all for always being here and supporting. I'm about 15 subscribers away from 1K. So man, any kind of jamming the like button, sharing, anyone who hasn't, hey, how you doing, Virgo? Anyone who hasn't subscribed yet, please do. Everyone counts right now, and just trying to get the good word out there and see what we can do. I realized, I guess, a little bit before I started this channel that considering the content that I was planning on at least coming out with, that, the algorithm probably wouldn't do me many favors, but I have been very fortunate to have incredible subscribers and people coming on pretty much every day. So thank y'all. Any support, very much appreciated. So yeah, tonight, I'm not going to try to keep y'all very long. I really just wanted to go over, in the hearing where judges to issue the order. Hopefully we'll find out Utah County Prosecutor's Office. Maybe a few streams ago, about a week ago, understanding of the dynamics and the substantive arguments on each side of this equation. I will say, wait till the end though, because while reading this, as a matter of fact, today I read the prosecution's response to the defendant's motion. And that's where most of my notes came from. But man, I saw a couple interesting things that really play into the due process, the evidentiary, conversation that we've been having, whether it's Terrell Farnsworth and the SD cards, just the total contamination of the crime scene that we had to witness, all the way to the actual cover up. Take down corruption. That's what we're trying to do. Boomer Ball is what we're trying to do. But anyways, I found some incredible information in regards to that. I say it's incredible. It speaks to it. I'll put it to you like that, in the prosecution's response here. So anyways, oh, did Greg already do a video? Oh yeah. So Susan, we did a live stream yesterday. I think there might've been an issue with the video. I will get with Ali about it, but we'll get it back up if so. So anyways, I'll get back with y'all on that. So anyways, yeah. So the motion was this, and it was filed in January. I want to say that the parties became aware of the potential conflict before January, but we'll get in that in just a second. So here's the motion. So basically the defense is wanting to disqualify from representing the state of Utah, right? And I'm pretty sure everybody has an idea of how, district attorney offices work. They're basically attorneys or agents of the state, but they have their own county office divisions. But generally, as what the felony level anyways, whenever there's a criminal indictment, or in this case, information filed, it's filed on behalf of the state, in their local county regional office. And so here there was a motion to disqualify the entire Utah County Prosecutor's Office. And so if some of y'all might not be aware what the original basis is, that Grunander, I think his name is Chad Grunander, which is, I think, second in line at the Utah County Prosecutor's Office, had an 18-year-old daughter who was actually present in the crowd. I want to say maybe 70 to 80. Come on. Okay, there we go. Sorry, y'all. Whew. Okay. Anyways, I am connected directly with Ethernet into the router. Anyways, the 18-year-old daughter of Chad Grunander, who's second in line at the prosecutor's office, was at the event that day. And hopefully it's coming back on, Elena. It's looking like it is here. Will y'all let me know if I'm good? Okay, back. So the 18-year-old daughter was there. Defense is saying, hey, because Chad Grunander, who is second in the line at the prosecutor's office, because his daughter was there, it injects a certain level of bias, or what we could say, bias or prejudice, meaning that, Chad Grunander and the attorneys working under him, because his daughter was there, it's going to affect his decision-making process, essentially, okay, and make him be more Billy Bad prosecutor than might be warranted under the circumstances. And here's a death penalty case, right? And obviously, as far as I'm aware, the day after the event, there was a press conference, but I think it was actually the governor of Utah announced it, I guess, or it might have been the attorney general, more or less announced it. Now, the official notice to seek the death penalty with the required allegations, the enhancement, as they would call it, was not filed until the 16th. I do believe the same day that they filed the information, which is the document, the pleading, which is now currently keeping Tyler Robinson in custody. Okay. And so obviously the defense pointed at that and said, look, Judge, that's all the evidence that you need. You see how quick that they came with this, death penalty case. And that was kind of the impetus or the evidence of the fact that, this is going to be an issue moving forward. There's a conflict of interest. And so let's see. Okay, so here's a funny thing. So obviously part of that argument is saying that, because Mr. Grunander's child was there, obviously she experienced some type of hurt or trauma, which, there were thousands of people there. And I think people have reported that it was pretty traumatic. to be there in that situation, which I'm sure a lot of people didn't know at first. I mean, there were some people, the way they acted, I think they knew that it wasn't like a live shooter event, but people that are there who otherwise didn't know wouldn't have had any clue. And so they were probably literally running for their lives. Now, allegedly and magically, Grunander's daughter was not looking in the direction of Charlie Kirk at the time that the incident happened. And so therefore the testimony is that she did not suffer any kind of major trauma. It's alleged that she didn't skip a beat, that she made all of her classes. I don't know if she still where she works, but anyways, didn't skip a beat. I did learn today too, and we'll talk about this at the end because it's one of those interesting things that I learned. But according to the timeline as alleged in the government's response, Grunander and other prosecutor office personnel showed up at the scene at the command center, I think as early as an hour or an hour and a half after the event occurred, right? And so again, we'll talk about that in the context of what we saw with the crime scene, but just wanted to put that out there. And so I think I got the death penalty notice. And there's thousands of eyewitnesses. And one thing I'll say too, and I want to throw this out there, and maybe I need to send an email to Barron and them or get a hold of the people doing the timeline. But I looked at there's some text messages. And so Grunander attached some of the text stream between him and his daughter and his family right after the event. And it was just interesting. One of the texts that Grunander sent, I think like literally 20 minutes stating, the shot came from the roof. You know what I mean? The alleged thing to me, how quickly he had made that assessment. And I'm speaking about the 911 calls, and he had worked out some kind of covered the rooftop area, took the prone position at timeline. Maybe that came before anybody otherwise had an indication that that was the case. And so again, just one of those little tidbits. I'm going to look into it. But interesting. So real quick, what is the standard for when, in these instances, whenever of interest along these lines, what's kind of the standard? Well, obviously a prosecutor cannot allow their bias or prejudices to affect their discretion, the exercise of their discretion as a prosecutor. In this instance, whenever there's they might be more prone to go after more punitive charging, make a more punitive charging decision than, might be sufficient or otherwise would be, made under the circumstances, I guess I'll say, right? And so that's one of the worries. The standard says that, and don't get me sitting here trying to fully define it, but it's a concurrent conflict of interest, okay? And so apparently a concurrent conflict of interest occurs whenever there is a significant risk, and this is in the context of a prosecution, whenever there's a significant risk that the representation of the state would be materially limited. And so one of the things in this instance, right, is that because Grunander's daughter was there, if he's going to be representing the state, then they're going to want to avoid having to bring her on the stand. Okay. And so in the full context of their case, there could be an instance where, well, we really need her to come up to the stand and testify in order for the case to be successful. Okay. And so those are kind of the two ends here are, them having to dance around his daughter being involved. And then his kind of, does he have an axe to grind against Tyler Robinson because of any potential harm or injury that was, suffered by his daughter, which she's claiming that there's not. And so there was, not that there was a back and forth on that, but the defense did point out that, they had scoured social media, things, interviews with these witnesses, and a lot of people were pretty highly traumatized. Now, again, allegedly Grunander's daughter magically was looking the other way, hey, whenever the Charlie Kirk incident occurred. And so, based upon that, she alleges that she's not suffering any major trauma, at least not to the level that it would affect her daddy bear's decision-making process in this prosecution. And so let's see. No. Okay. So another thing too is you might say, well, the defense wants the whole office to be disqualified, right? Well, what about just, telling Grunander to step aside and letting the other attorneys in his office litigate this case? And to be quite honest with you, judge might very well do that. And I'll talk at the end about my kind of specific predictions in regards to judge, but that would be kind of a negotiation, right? To where the defense asks for the entire office. Judge might just, he might just disqualify Grunander. We'll have to see there, but the defense, they're pretty solid. They want the whole office. And the reason why that is because normally what should have happened, okay, in this instance, whenever it looks pretty early on, the death penalty might be sought, especially the prosecutors in the office should have been screened, according to the defense, should have been screened early on by the DA, Jeff Gray, and any of those who had a family member at this incident, like Grunander, should have early been weeded out and not put on this case. However, that didn't happen. And because that didn't happen, and it took them a while before they came forward with this conflict, the defense is now arguing because, Grunander's second in command, and he's working with all these other, junior attorneys up under him on this case, but he's biased. And so they're alleging that basically the whole office has been tainted and needs to be disqualified. Now, obviously, the state has a different point of view on it. Like I said first, their position is that Grunander's daughter did not experience significant enough trauma to affect Grunander's decision-making process here. Now, the next interesting point, okay, because a lot of it centered around whether Grunander's daughter is going to be some type of material or essential witness or not. Obviously, the state, their position was, hey, there were thousands of eyewitnesses there. Many of them saw much, much more than Grunander's daughter did. Therefore, they would obviously make the much better witnesses. But here's kind of the kicker, and we're going to talk about this at the end, right? Here's what they said. They said that, these eyewitness testimony, so basically people who were there at the scene, they say that their testimony is only marginally relevant. These eyewitnesses only marginally relevant, and it might not click on y'all immediately in the greater context of Tyler Robson's due process case we've been talking about, but just hang on to that for a minute because that's very interesting that they said that. But they further went to categorize these witnesses' testimony as quote unquote generic, and that they only provide contextual evidence, basically evidence to kind of set the scene. But otherwise, when it gets down to the nuts and bolts, nitty gritty of the state really, really proving its theory as elucidated in information, they're saying that these witnesses are not really material. And so therefore, whether they were to choose, just further, reason or explanation as to why, if they do not choose to use Grunander's daughter, which obviously if he's going to be on this case, they definitely need not to, but just further evidence as to why, her testimony is not needed, because essentially what they're saying is, in a nutshell, even the other people's testimony isn't super necessary. They're going to need it, obviously, to set the context and the foundation, but it's not crucial, critical type of evidence. Okay. Let's see. Okay. One other thing on what they brought up too, in regards to, could Grunander's daughter's trauma, even if she just suffered a little bit, affect his decision making? And they said, the rules allow for prosecutors to basically account for the trauma of third-party witnesses and victims in deciding, which moves they make as a prosecutor. And I guess just that argument would just kind of mute or blunt the blow of alleging that, his daughter's trauma would negatively affect or negatively affect his decision making in a way that's bad for Tyler Robinson. Now, we talked about the death penalty, right? So the defense was using the death penalty, and more specifically, how quickly they announced it, which I believe was in a press conference the next day. The attorney general or the governor announced that, but it was officially filed on the 16th, I believe, which would be about 6 days post the event, the incident, right? And so, they said because this was done so quickly, and if I remember correctly in the hearing, they even brought up the fact that when it was first announced, okay, not filed formally, but when it was first announced, they didn't even know who Tyler Robinson was. They didn't have a suspect at that time. And so again, another kind of tidbit to make you think like, wow, was Grunander's daughter being there, getting him hot to trot to announce the death penalty and eventually charge it? You know, my personal position on that was probably no. I think it was purely political. I think it was a purely political thing. And I think as we've progressed into this, it's become more. I think it's become more in I'm not going to fully elucidate it right now, but I think y'all know where I'm getting at, that like the push towards the death penalty. Well, I'll just say this. I firmly believe that the Utah legislature February 4th announced this, move to amend their death penalty statute. They want to expedite the death penalty. They want to make it appeal proof, meaning harder for defendants to challenge it on appeal, amongst other things. I'll just be blunt. And of course, this is some speculation, but I certainly believe now, based upon everything that I've looked at in context, that really that was a move to scare Tyler Robinson into a plea bargain, quite frankly. That's just my personal belief, based upon all the facts and circumstances I've been able to examine in this instance. I really think that move to amend the death penalty statute was intended to get to Tyler Robinson, whether it's through a news article or word of mouth in the county jail, and really, really factor in on whether he wants to really, play this all out or not. And obviously, I think there's an interest to try to get him to plea as opposed to going to a trial here. So, we'll see what happens. Yeah. Anyways, from a legal standpoint, the timing on the death penalty notice was congruent with the law. In Utah, they have, I think, 60 days from the arraignment to make that assessment and file the notice. Obviously, it still seems like it happened pretty quickly. I think normal par for the course would have dictated some more time in between those two things. In response, the prosecutor stated that, well, one, we're within the statutory period. Two, they state that, there have been plenty of other cases where it was announced very early on. They state that, well, there was evidence of it. And we could get into a whole debate there. And I will do some more episodes and we'll talk about the merits of the death penalty there. But one thing that really struck me is that they brought up this case where they learned their lesson in this case. And apparently the case, and I don't have the name of it. Let's see real quick. The name of the case that they cited, Jane, some Utah State case, Jane. But apparently in Jane, the prosecutor didn't make a, quick announcement of the death penalty. And apparently there started to be rumors that they weren't going to seek the death penalty. And I guess it got into the media, and whoever the prosecutor was had to call and set the record straight. These prosecutors really don't want it to be known when they're not seeking the death penalty. And that's another thing. Jeff Gray, and I think we've talked about this before. Hell, he campaigned on big death penalty guy, right? And they actually use that as reasoning here to say that, well, Jeff Gray campaigned. He had to, go full force here, apparently. And so I just, I just find that kind of ridiculous and crazy, just to be quite honest with you, that someone would be rushed into Yeah. Okay. Sorry about that. I think it's the weather. Hopefully I'm back up now. Anyways, back to what I was saying, these, stopping rumors, but for our purposes here, one thing that they said was that in other instances, failure to quickly announce the death penalty has led to conspiracy theories and misinformation out there. And they said, because early on people were stating all kinds of misinformation, and the conspiracy theories started immediately, according to them, because they announced that death penalty early, they went and filed that notice. They were trying to cut down on all that. And, from my perspective, and I think a lot of the people here on my channel would share it, is like, no, actually the decision to announce the death penalty made us fight even harder. Well, I say fight, but, investigate, looking at every single angle, because I know me as a member of the public or as a lawyer, whoever, as an individual, man, if someone's going to face the death penalty and I have an inclination that the evidence going into the guilt or innocent phase might not be the evidentiary record that I feel is required for a death penalty case, well, then, yeah, I'm going to be out here doing exactly what I'm doing now, because quite frankly, I think that's bullshit. And again, the thought that announcing the death penalty would detract or dissuade people who are quote unquote conspiracy theorists, or quote unquote spreading misinformation, I just don't buy that at all. I think it's complete bullshit, to be quite honest with you. Pardon my language. So anyways, with that being said, that's kind of the crux of the back and forth there between the defense. And like I stated, as far as the whole office being disqualified, obviously the argument there was that, Grunander's top dog, second in line. He's been, had a conflict of interest, yet he's been allowed to more or less lead this case for how many ever months. And so because these other lawyers have been working for him, therefore the whole damn office should be disqualified. And so anyways, that's kind of the stage. What do I think the court's going to do? Well, unfortunately, I definitely don't think the court is going to disqualify the entire Utah County prosecutor's office. I've learned over my years practicing law that these judges in the prosecutor's office, a lot of them come from the prosecutor's office. They develop a close working relationship because, unlike defense attorneys, prosecutors are in these courts pretty much every day. And, just naturally, they learn, they end up growing kind of close. So I don't see Judge throwing the whole office out of there. Maybe there's a slim possibility that he does disqualify Grunander. I don't know. Again, I wouldn't be surprised if not even that. And I think probably the main justification we'll hear Judge give is because she's not a material witness. And because Grunander has attorneys working under him that, to the extent he has bias that's affected his decision-making, he has other attorneys there essentially to act as a check. And again, this is just me musing. I don't know that's what Judge is going to rule or his reasoning, but I do feel if he fails to or refuses to disqualify him, I think because she's not quote unquote a material witness will probably be one of the main sticking points for Judge in deciding to, deny the defendant's motion essentially. So anyways, let's finish up here on this last note about the evidence that I said. Now there is, again, the fact that the prosecutor stated, and let me read it again because the language that they used was really eye-opening to me, but stated that basically all these eyewitnesses at the event, their testimony is only marginally relevant in generic, and it only provides really there to provide context. So in the whole grand scheme of how they handled the crime scene and how they've handled the evidence to date, well, what does that tell you? Well, it tells me that they've known and that they do consider all the other evidence, talking about video evidence. I'm talking about forensic evidence, at least the forensic evidence that they all gathered up there at the rooftop that day to make sure they got all that, down pat, that they consider that evidence is crucial and very important. And so the fact that they allowed the scene where, in quote unquote, the main scene where Charlie Kirk was sitting at the time, that they let all this stuff happen right after the incident and then eventually covered it over. Well, that seems to indicate me a little bit more strongly than before that there might be an element of bad faith there, because they're basically telling us that this evidence, by implication, this other evidence is not marginally relevant. It's very relevant. And so with that being said, seemingly they intentionally paved over what they themselves consider to be relevant evidence, right? And so as we move forward, and I know probably plenty of y'all saw the video that I did, I think it was yesterday, day before, about the man being arrested, right? So the day after the event, they arrested a man who was caught inside I guess by that time they had actually put a couple rounds of police tape some man was discovered inside of that area taking selfies or taking photos, and was arrested on suspicion of obstruction of justice, which again is a related statute to the tampering with evidence statute. And so right there, it shows you again. So obviously they felt that that area, that evidence has some importance, right? Is relevant. Okay. So it just makes it, the fact that 5 days later, or 4 days from the time that the guy was arrested, they paved it over. Again, it just shows. Obviously, why would they have paved over that scene whenever they've admitted already, at least by implication, that all that evidence is really the nuts and bolts of the case? But I think more properly what it was is that they know that was the nuts and bolts of the defense's probable case, right down there where Charlie Kirk was sitting, in that they more or less did everything they could to preserve and properly process the evidence that was on top of the Low C Center or wherever. And so I wanted to bring that up kind of at the end here, because it's part of our continuing conversation on Tyler Robinson's due process rights. And so now I have a few more nuggets of information. I'm going to go back and whip out the due process analysis under Article 1, Section 7 of the Utah Constitution. And I'll come back with another live stream. We'll dig into it further. I'll probably actually make some charts. And so that way we can visually look at the evidence that was paved over, contaminated, lost, carried away. What's the standard? What can we infer as far as bad faith based upon what we know? So yeah, we'll keep refining that as we move forward. Obviously, the prosecutors continuing to make statements which draw into question, whether they're completely innocent in that deal. And so yeah, we'll keep following that train. Yeah, but that was about all I have for tonight. Let me look at the comments real quick before we hang it up here. Ali, hey, Susan. Yeah, multi-tier level of justice. Yeah, Elena, multi-tier level of justice. Yeah, it's insane, isn't it? And there's no hiding it anymore. A lot of these officials, these politicians, they don't even feel the need to hide it. And I don't know if that's an indictment against them or more of an indictment of us. But I think that it's really an indication that come midterms, come next election, I think we all need to kind of take a look and see what are we using as criteria for voting. And, I think that there's one foreign lobby out there that, if we find out that these politicians that we're looking at are on the take from that certain foreign lobby, well, might want to reconsider a vote for them. Just my opinion. All right, let's keep going. Let's see. Boomer Balls, good to see you. Is this your first time joining us? Good to have you. Susan, I hope I clarified the thing with Ali Files yesterday. And I'm going to get a hold of her when we're done here. I very well might be doing another live with her tomorrow for the court, if we can figure out how to get a link and get connected with it. Linda, how you doing? Lisette. Let's see. All right. Well, how has Beth Weinstein been a resource on your Enthea? Oh, Beth Weinstein? Man, yeah. Virgo, email me if you can. Yeah, Beth is good people. Man, I've known her and worked with her for quite some time now. Multiple years. So yeah, thanks for bringing her up for sure. And I probably need to get in touch with her. It's been a while. Anyways, and just to be honest with y'all, I'm a little sick. My wife got sick. I'm a little sick. I'm probably going to hang it up a little bit early tonight and get some sleep, but hopefully I'll be back tomorrow with Ali Top Files. If not, I'll either do a video or do another stream here with me. Real quick update. Like I told you, the downstairs, the studio is pretty much done. I got a desk on order. I got a camera on order, and then I'm working on getting I've got some cool, these wooden, 3D, sound cubes that I'm going to do for the background, and some other cool things. So man, stay tuned, and yeah, it's going to be cool. Thank y'all very much for all the support. Much love from me. And yeah, if you haven't already, if you're new here, please like, comment, definitely please subscribe. I'm short about 15 subscribers from the 1,000 mark. Huge milestone for creators. And, if I was to get there by tomorrow, would be incredible. I'm very appreciative of every subscriber. And if you haven't subscribed to my channel, we have a really good comment section. We have some pretty productive conversations there. We don't go at each other's throats, even though we disagree at times, and people have really been enjoying it. And so if that's something that interests you, seeing good informative videos with a good informative comment section where we're learning from one another and loving one another, that's going to be the channel for you. Thank you, Lisette. My big thing on this channel is, moving away from this highly polarized political environment that we exist in. So my content, whether it's legal, political, is really going to be geared towards that. You're not going to catch me bashing one party or the other. If politicians are corrupt and if they're, perpetuating this two-tier system of justice and some of the other things that we see going on that aren't good, I'm definitely going to be getting after their ass. But otherwise, it's on this channel, we're going to be moving towards remaining objective and really tackling a lot of these tough political issues with the proper frame of mind, right? Okay. Anyways, that's it, man. Much love to y'all. I'm fixing to go get a bite to eat, and I'll be back with something tomorrow. If I'm going to be with Ali Files, I'll do a post in a bit and let y'all know. But that's it. Thank y'all. We'll see you. Thank you, Susan. Y'all have a good one. And yeah, y'all see me tomorrow. Thank y'all.